Okay, good afternoon, everyone. Hope everyone can hear me. And welcome to today's digital roundtable. Our topic for this afternoon will be 558 developer claims. My name is Doug Weinstein. I will be moderating along with my partner, Daryn Gursky, for this afternoon's webinar. I am Director of Operations, Vice President of Operations for AKAM. On site, we are a South Florida and New York-based property management firm, and I am pleased to welcome and to be joined by Daryn Gursky. Mr. Gursky is an attorney that specializes in the practice of community associations law, including construction defect negotiation, litigation, turnover representation, covenant preparation and enforcement, and he's also proficient in collections for those of you that might want to take advantage of that. He has lectured extensively on a series of topics affiliated with community association operations, legislation, and related legal rulings. He is a partner in the firm of Gursky Reagan, and we're glad to have you on today with us, Daryn.
Thank you, Doug.
Thank you. To start out with, 558 is something that has been brought to the forefront with the number of new construction buildings that have taken root in the South Florida area over the past few years, and which will continue to be in the forefront with the number of developments coming online down the road. So I think the best place to start is, Daryn, for you to give us a little bit of a background on the 558 and what's also known as developer turnover, which are not really the same thing. So I think if you could go into the history and then basically go into what the differences are, and we can go from there.
Yeah, thank you for the introduction, Doug, and I appreciate sitting here at this roundtable, digital roundtable with you today to discuss 558 developer claims and what that means with relation to turnover, as you mentioned. Turnover is the process in which the developer has sold a certain number of units at their property and turned over the maintenance and operations of the association to the unit owners. That is generally dictated after 90% of the units have been sold and or 95% in the association. Developer gives the unit owner board that ultimate control. And a 558 developer claim relates to construction defects at the property. Construction defects and design defects that impact essentially the intended use and the fitness of the property. Those defects can range anything from a code violation to the usefulness of the air conditioning unit on the rooftop. There are various different components to it, and a 558 claim will not be able to initiate, obviously, against the developer until such time as turnover has occurred. Now, a 558 developer claim, really it's Florida Statutes Chapter 558. And that claim can be brought not only against the developer, but also against the general contractor, subcontractors, as well as other designers, the architect of record, the engineer, the structural engineer, the civil engineer, as well as any other designers associated with the development of that project. So it is incumbent, and I recommend this to all my turnover boards, that they explore a 558 claim, because for better or worse, there is no new construction property here down in South Florida that doesn't have some or has not experienced some level of a construction defect impacting their property and creating some level of consequential damages associated with that construction defect.
Yeah, exactly. And as property managers, we see it from an operations standpoint and from our management view of the building. I just wanted to make a comment to our attendees that should you have any questions, please go into the Q&A portion of the Zoom and list them, and then we will get to them at the tail end of our roundtable. Daryn, when should a building or the membership start this 558 procedure? And if you could give us a walkthrough of what that procedure entails, that would be helpful.
Yes. So the 558 procedure really starts with the association engaging an engineer. The engineer is the appropriate person for the association to identify the series of defects at the property. And when I say a defect, what I mean is a couple different items. I mean either a code violation as a result of the construction, or a defect in that the construction did not meet the industry standards, or that the construction did not meet the intended use. And the 558 process requires that the engineer provide a report specifically detailing those issues, and then the association has to put the appropriate parties on notice, whether it be, again, the developer, general contractor, subcontractors, and designers. And the purpose of that is so that there is a pre-suit and a pre-lawsuit process in an effort to resolve these claims without the necessity of having a litigation. A lot of times there is not the wherewithal to engage in litigation by an association, and likewise, it's an effort so the parties can eliminate having to spend money on litigating a case in hopes that a reasonable resolution can be reached to repair and or provide money and or provide an explanation as to the deficiencies noted in that report in order to bring some resolution. So what we see a lot of times, Doug, and I know that you see this as well in your experience, is during you're on board, and generally the lawyer is not, but the property management is on board prior to the turnover, and they prepare a list of items that they identify during the pre-turnover process of areas that are being affected, whether it be the curb at the valet is too high and every time a door is opened, it bangs the curb, to something like the elevators continually shut down because maybe the fire suppression system keeps going off and shutting down the elevators, or there's a water intrusion in the roof. And while AKAM will make note of these issues and put the developer and general contractor on notice for a warranty claim, not always do those general contractors or developers address those issues during that process, and they require ultimately the turnover board to engage an engineer to identify those conditions, point out the specific code violation and or alternative plans that were performed, and then I put them on that written notice. And that's how you initiate the claim. And when you initiate the claim, I send them a letter. In that letter, it identifies, pursuant to Chapter 558 of the Florida statutes, certain timelines required by the parties receiving that notice. So in those notice requirements, in the event that a property has over 20 units, within 50 days, those parties have the ability to inspect the property to confirm those repairs. This is really the process, if you will, of the 558 claim. I don't know if that's the next slide. Did I get ahead of us?
No, exactly. That's exactly what we're talking about. Now, one of the things that we get asked, Daryn, is, you discussed and you gave some great examples of things that are having to do with, whether it be the common areas of the building or the mechanical, the electrical, the plumbing components. And quite frequently, we'll get asked by unit owners, well, you know what, I've had a problem with the developer, my Corian countertops are stained, I can't get any satisfaction. Is that something that is included in a 558? in terms of a defect which a resident or a unit owner would say that is within the dwelling unit?
So generally, a 558 claim includes all components that are part of the common areas or common elements of the property. Right. The only time a unit owner or a condition within the unit becomes part of a 558 claim is if it's a common issue amongst all owners. So for example, and that's a good point, the countertop generally would not be a good example of something that would be included as a claim for the property. However, a unit owner may, under their own sales contract, have their own personal 558 claim, or warranty claim in that sense. But in the scenario where a unit owner is required to maintain their own air conditioning handlers, or is a good example, a lot of times there may be a deficiency with a series of 20, 40, or 50 different handlers that were submitted to the property, and all of them have the same consistent issue, whether or not they were installed improperly, the ductwork wasn't installed properly, or there's a issue in terms of heating of or air conditioning of the air conditioning down here in Florida of the specific units. So in that sense, because it is common amongst the unit owners, then it could be incorporated into the claim. So what happens is, and I'm glad you brought that up, is generally whatever engineering firm the association engages to perform this inspection, they will send the unit owners a questionnaire. And that questionnaire will say, point out every issue that you are experiencing in your unit that the developer has not addressed or the general contractor has not addressed in response to any warranty claim that you've made. And then they incorporate that into the report that is ultimately issued in that 558 notice. Now, going back to that notice, Doug, because I want to make sure people understand, because there is a timing component to these claims.
Exactly.
And it's not, unfortunately, for better or worse, it's not something that gets resolved right away. And sometimes that's problematic, as damages are sometimes aggravating during that process. Unfortunately, it's a situation where a 558 claim can drag on for maybe potentially at a minimum 6 months, sometimes longer, depending upon, again, whether or not you litigate the case. But the purpose of the 558, as mentioned, is so you can attempt to resolve the claim without litigation. So what the statute provides is, if it's a condo or a property that has less than 20 units, within 30 days, those parties have the ability to inspect the notice that has the engineering report of the defects. If it has more than 20 units, it's 50 days. And then assuming they undertake that inspection, within 75 days or 45 days, depending if it's less than 20, of receiving that notice and they have to provide a response. Now, the response takes down every single item identified in that report. And every report has, could have anywhere from 10 to hundreds of items. And every single item has to be responded to. And the response is, we acknowledge and will repair. We acknowledge and will give you money so you can repair. We reject, or let's discuss it. And ultimately, in the event that you can come to some sort of discussion point, and if it breaks down, then after 120 days, the association has the ability to file a lawsuit in compliance with the 558 statute. So we're on this slide right here. What is a successful resolution? I didn't want to steal your thunder.
No, I just wanted to your point, and something that we also face, again, as managing agents intimately involved in the process. what is your, because what we'll face is if there's a quote unquote construction defect that is adversely affecting the operation of the property in current terms, what is the responsibility of the board to alleviate that, even though it may be something that is within the 558, but we need to handle that sooner than what the resolution for that 558 may be?
Great question. Under 558, the association has the ability to put the developer and general contractor and all those parties on notice of the necessity to undertake an emergency repair. And like you're saying, a lot of times some defects cause consequential damages to other components of the property that need to be resolved immediately, or otherwise the association will continue to incur additional expenses, and you just can't operate a property that way. And a lot of times that also affects units and people's living situations. Elevators are down, potentially mold may grow in a unit, or also there's a life safety access issue that's implicated. So in those types of scenarios, what we can do is we can put the developer and general contractor on notice and say, if you don't, here's a short window to undertake an inspection. And if you don't undertake a repair within a short time frame, we're going to undertake that repair and we're going to seek reimbursement of those expenses directly from you. And the statute provides for that, as well as the law. And a lot of times there are certain conditions that really make sense to do that. A lot of times there's issues of water intrusion. I'm sure you see it all the time.
Absolutely.
And whether or not it's from the roof, from a crack in the stucco on the side, or a window wall, all those particular areas, you know, water is coming in. And unfortunately, I haven't seen a planter down here in Florida that doesn't leak either, as I suspect you too. And those particular components of the property, if you just let them continue to leak, greater damage will happen, and the association needs to act as a requirement under the laws to mitigate your damages.
Right. I think it's very, very important information is that, you know, we do need to take care of things that adversely affect the property, whether it be, as you said, water infiltration or a life safety issue, you know, fire alarm issue or piping or whatever. So I think that's very good advice. And as you said, the statute provides for a remedy for that as the 558 process code continues. So let's go to the process itself. You know, we've had the engineering report. Let's take the worst case scenario in that the developer is, again, not cooperating, not offering any olive branch, so to speak, or what is the litigation like should an association be forced to go that route?
Well, you know, let's say, for example, you know, and before maybe we discuss getting into litigating the case or the initiating litigation process, going back to the concept of, let's say we receive the responses after the 75 days from the developer, general contractor, and let's say they're, you know, hit or miss on a few items, and maybe they're not agreeing to reimburse the association for some of the items that the association undertook itself, and then there's a rejection. You know, I always try to exhaust the process, because a lot of times it doesn't make sense for the association, in fairness to the unit owners, to expend money on the lawyer when the money really is necessary in order to undertake these repairs. So I try to exhaust the process and really push the parties in a position where hopefully I can invoke the developer as well as the general contractor's insurance carrier to get an adjuster involved. And the adjuster can see, and with my firm and some other firms, we're reputable enough where the adjusters already are aware of us and know that I'm willing to take a case like this to trial. So in an effort to eliminate having to go through that litigation process, expend that money, it makes more sense to spend the money to resolve these claims. And sometimes if you're dealing with a less reputable developer around town, they seem to be the developers that are not necessarily as cooperative. And then if you're dealing with a lot of the reputable developers around town, they recognize that they have a customer base. They want to stand up for their customers. So they're going to help actually assist, maybe by pushing their own insurance carrier, as well as pushing their general contractor to seek a resolution of the claim. Obviously, a successful resolution of the claim is getting 100% of the items noted on your engineering report undertaken by one of the parties or paid for it. Do you always get 100%? No. Do my clients expect 100%? Yes. Do I want to give them that? Obviously. But a successful resolution really entails making sure that the significant items addressed on that report are resolved to the point that they will not be a continuing issue in terms of the ability of management through its systems to be able to properly maintain the property in an effort to avoid those damages as a result of the defect.
Yeah, I think that's some great advice. And we get asked in the buildings that we've had that have gone through the process is during the course of that negotiation or with the developer and the GC and potentially the engineer architect, we get asked a lot of times on an item, should we have the GC or the developer correct it? You know, we're fighting them, we don't have a good relationship with them, or should we look to actually get funds to do that and we do the work?
And that is I get addressed that same question too, because it is questionable. I'm having the person that seemingly screwed this up from the get-go come and now fix it and attempt to resolve it properly. I always say the idea is, yes, let them fix it, but our engineer, the person who did the reporting, is going to sign off that the repair was done properly. That way there's comfort that the person that we're trusting who pointed this out is going to sign off. And then that sort of extends the liability that in the event that it wasn't done properly, some other party is out there that potentially is on the hook for recognizing that they should not have accepted that particular repair. Also, in the event that the developer and general contractor, their people do that work, then that warranty on that work will remain. So we still have the ability that, let's say in the next few years, it falls apart again. Hey, we can come back to you. You didn't do it right. And here's why it didn't work. Or if it didn't work right at that particular moment. Now, there are a couple types of claims here that we're talking. You know, there's a patent defect claim, which is a claim that is perceptual. Just right off the bat, I can see it with my eyes. And then there's a latent defect claim, which is a claim that manifests over time and is generally uncovered. Generally, the latent defect claims don't manifest right away. So sometimes the 558 process, there's two processes, one immediately after turnover and one that happens a few years later. It just depends upon how sometimes a defect that's uncovered or hidden manifests.
I think that's a great point. And let's go into that a little further. As you mentioned, you know, you may have a latent defect that's obvious to, you know, at that time. And then how is that defect that's discovered down the line treated? What is the association remedies for that?
So during the initial 558 claim, you're pursuing everything that was really identified during that turnover process, just after turnover, prior to turnover, and the developer does a full property evaluation. Literally takes days, goes through every single corridor, floor, every corner of the roof to everywhere in the mechanical rooms to test every system. So it's a pretty thorough investigation. And after that pretty thorough investigation, your claim is solely based upon that investigation of what you point out and what is addressed in your notice and on the report. So if you're going to ultimately resolve the claim, or it leads to litigation, which we're going to probably talk about shortly, you're only litigating those particular issues or resolving those issues. And you have to be cognizant of, when you do ultimately agree, whether it's in a paper settlement agreement or signing off on a repair or litigating the case, that's all that encompasses the case. Because as you mentioned, and I pointed out too, a latent defect which manifests over time has a farther statute of limitations in an effort under Florida law, recognizing that these issues come out later on. And so it's incumbent upon the board and their counsel to ensure that you preserve those rights to pursue those claims later on. And you and I see it all the time. A post-tension cable, which is hidden behind the stucco system that nobody ever sees, all of a sudden rust starts coming out of the side of the wall. Well, where did that rust come from? Why would there be metal behind the wall? Well, an encapsulated packet all of a sudden is no longer encapsulated because it wasn't properly grouted, and now it's prematurely corroding. That's a code violation and a construction defect. Or also, another one that we see all the time, and I know you see it all the time, is an improper valve is installed. We would never know the valve was improper until such time as a flood happened, or until such time that there was some sort of surge in the plumbing. That those issues don't happen until they happen. And there's no way of testing those systems, and you don't want to necessarily test those systems. You have to assume that the property was built properly because it was signed off on by the either threshold inspector or the city, because the system comported with the design, but there was a defect in the installation.
And I think one of the things that's been brought to a head recently is, our audience and down here in South Florida was and is still going on, the litigation and everything concerning the fire suppression piping systems that were installed in buildings with PVC and CPVC that didn't manifest itself until many years afterwards. So, and you're 100% right. We see it in sprinkler heads that, were not installed and burst prematurely or let go prematurely. So that's very, very solid advice on that. And I think that's a good segue into the litigation process. So
the litigation process comes about when obviously the 558 pre-suit process failed. We were unable to achieve a reasonable resolution with the parties. The repairs and or money being offered didn't necessarily account for what was required to bring our property into the condition in which we purchased it and believed it was being delivered. And sometimes that is an unfortunate scenario, because a lot of times, and this as well as I, your unit owners, my clients will say, this is the biggest investment I've paid in my life. this unit right here, I put all my hard work, money into this as my home, and it's really disappointing that every time the person flushes their toilet 3 units over, water comes into my unit, and it is disappointed. Unfortunately, whatever repair was offered, our engineer is saying it's not going to work, and or there was no offer to repair it, so we have to litigate the case. Now, what happens is this. What I generally do is most of the claims involve a multiple number of parties. I mentioned at the beginning that the 558 notice would be against the developer, general contractor, architect, engineer of record, structural engineer, civil engineer, and a series of subcontractors. Assuming that this building has issues impacting all those parties, I like to bring them all into the lawsuit right away. And I file a lawsuit in what's called the Complex Business Litigation Division of the Circuit Civil Courthouse. If it's Broward, Dade County, West Palm Beach, or any other county here in Florida, generally they have a complex business division within that Circuit Civil Courthouse. And what that entails is when you file it in that complex business litigation, or sometimes maybe in federal court, it allows for you to prepare what's called a scheduling order or a case management order. So I filed the case. The case would be a breach of warranties against the developer and general contractor and the subcontractors. And the breach of warranty is pursuant to 718-203. Now, the developer and the general contractor have slightly different warranties. The developer is a warranty of fitness and merchantability for the purpose or uses intended, whereas the general contractor's warranty is an implied warranty for the work performed and the material supplied. So it's slightly different, but essentially the same concepts apply. And then also I pursue a negligence claim for a violation of the minimum building codes pursuant to Florida statutes chapters 553. And these aren't a lawsuit. I allege them against all the parties, and I put it into that complex business litigation division in the circuit court. Now, when we get in the circuit court, generally it takes about 20 to 30 days to serve all the parties, and the court will require all the parties to come to a hearing, a case management conference hearing. And they also require all the parties to bring one of your clients with you, and the judge will say, this is what's going to happen in the case. You're going to enter into a case management or scheduling order, like I mentioned before, and there is going to be a trial date set for between 16 and 22 months out. And within that amount of time, you are going to litigate that case. We're going to condense it. And in that time, it's fair to my clients, because a lot of times what you hear and I hear is, I don't want to get in litigation because now I'm in a 5, 10-year process, and that's going to drag this out. Meanwhile, the property is deteriorating. We have these defects. How can I live like this? So I like to speed up the process. It's not fair to the clients. It's not fair to the association. And like we mentioned, it's these people's biggest investments of their lives. So we want to make sure that we sort of speed up the process in an effort to help them get the property in the condition that they purchased as customers. And then through the process, you go through discovery. They question our engineer. And our engineer has the obligation to substantiate the defects that it found. These cases are engineer driven. My clients, the unit owners, all they can testify to is what they're experiencing and the damages that they're facing. Ultimately, the engineer is the party that has to substantiate the various deficiencies at the property, the code violations identified, and the construction that did not meet the industry standard. And that can only come about once you've exhausted that 558 process and identified that there's no point in negotiating and you have to initiate the litigation. And, you know, unfortunately, and it happens with a lot of people, and I'm not just saying developers, but in a lot of business sense, unless you initiate litigation, sometimes the developer or general contractor don't or can't appreciate your level of seriousness in the claim, and the litigation will obviously prompt them to potentially seek to resolve the claim immediately thereafter, recognizing the board and the association's wherewithal with respect to the claim.
And also, let me ask a question. That's something that we get asked a good number of times. Is there any culpability from municipalities here? Like, for instance, you know, you mentioned before about sign-offs, and it's signed off by the threshold inspector, which is a private inspection, or signed off by the city, or they approve something in the initial plans that turns out to not be code compliant. Or so is there any culpability with a municipality on this?
Generally, no. Generally, the municipality is immune or has sovereign immunity with respect to it.
Right.
And the reason that is because when the developer has its architect submit its plans for permitting, it goes through a series of meetings with the city to confirm aspects of the plans meet code. They go through technical advisory committee hearings. It gets sent separately to fire and code, and then public works. So there's a process entailed, but there's two types of inspectors, and I mentioned it and you mentioned it too in your question. So there's a process under the Florida building codes and through the building department that allows developers to engage what's called a threshold inspector that essentially sits in the shoes of the city to sign off on various components of the construction. Now, if they signed off on a code violation and issued it to the city as signing off essentially on that component of the plans in order to allow for the city to issue a certificate of occupancy, they do have liability. And their liability will run through their contract with the developer, as well as negligence directed at the association from the association.
Exactly. Is there any during the whole process, and you touched on it briefly before, is, you know, the insurance carriers for the involved parties. If you could just talk a moment about how does that affect the claim? What do you see in when these things are adjudicated? Is it mostly done through the carriers making offers, or is it done through direct contribution by the parties?
So I would say about 10, 15 years ago, in these construction projects, how they used to be set up is there would be a developer, and then the general contractor was required to indemnify the developer in a 558 construction defect claim. And then all the various subcontractors had their own general liability policies. And when you went to a litigation, everybody's insurance carriers came on board. Now it slightly has changed a little bit. And what's transpired in the industry is when a developer seeks to initiate one of these projects, their lender for the project will require what's called a wrap policy or an inclusive policy. And that policy is, in unit owners will hear this, a CSIP or an OSIP policy. And what that is either a contractor controlled insurance policy or an owner controlled insurance policy. And it's a construction policy whereby all the parties are indemnified under one policy, and they have to have the same indemnity type contractual relationship with either the owner, meaning the developer, or the general contractor of the project. And so when you sue a lot of the parties in the litigation, the adjuster of that insurance policy is required to pay for a lawyer for all those parties. So they're spending a lot of money. If you more parties you bring in, the more money they're going to have to spend on litigating. So the adjuster sometimes will have direct contact with me or have a separate conversation with their insurance appointed lawyer and myself to go through the issues in an effort to attempt to resolve the claim. Likewise, because you mentioned it too, what do the parties' relationship have with that insurance carrier adjuster? So if it's an owner controlled, the developer is controlling that policy. If it's a contractor controlled, the contractor is controlling the policy. When it's the developer and an owner controlled, they generally push the carrier to try to resolve the case sooner rather than later. Again, these lawsuits are implicated against the developer and the developer's reputation. The developer sells their product based upon their reputation, and their reputation is only as good as the product that they can deliver. So there's a lot of publications that come out. As soon as I file a lawsuit, these publications will pick up that lawsuit and they'll say so-and-so developer was sued for construction defects that entail, and they'll list it on a publication. Developers don't want that. So they don't want that at all. So they push to seek to have their carriers resolve the claim. Contractor controlled policies, generally the contractor will fight it a little bit more because they see it as a little more personable, that you're questioning the quality of their work. Granted, there's no reason an association would pursue a claim unless there was reality to it. So generally the adjuster identifies that, respects that, and the adjuster, depending upon the adjuster, will attempt to resolve the claim relatively early in the litigation in an effort to, again, save money instead of throwing good money against bad money and hiring attorneys to represent all the subcontractors. And then some adjusters, want to go through the process and see the wherewithal of the association to establish a prima facie case of each defect and then make a determination of whether they wish to resolve it.
Very, very informative, again, with the insurance companies being involved. Now, one of the things that everybody has an interest on that goes through this, obviously, and I'm sure they asked it right at the beginning, is how long is this going to take and how much is it going to cost?
It always comes up because look at, the tough part about being in control of an association and the expenses associated with an association is its unit owners paying the fees for the attorney, unit owners paying the fees for the engineer. And does it make sense to pay for an attorney and an engineer if I can pay a few bucks just to repair it? And there's no sense in throwing, like I mentioned, good money away to bad money in the insurance sense, but in the same way here. And so always, if there is this, it is prudent and incumbent upon that first board after turnover to do this inspection regardless, because you don't know essentially what you don't know, what's wrong with the property, and there are issues that are wrong. The wrong pipe was used, and if you don't point that out now, in a year, that pipe may explode and impact 20 different units. So you have to go through that process. And how much is it going to cost? There's a varying number of engineers that are extremely reputable in the community that charge anywhere from potentially $15,000 to $20,000 to upwards of $100,000 for the type of inclusive report that you may be looking for, as well as additional inspections that may be required for the fully substantiating of those defects. Now, the legal process, again, obviously lawyers charge different amount of money, but generally this type of process can cost anywhere from $50,000 upwards of a couple hundred to $500,000 worth of fees. Some lawyers will allow for this to be done on a contingency. Some lawyers require somewhat of a hybrid type fee structure where it's a lower hourly rate and a contingency at the end, and some just do a pure hourly type fee structure. Ideally, you want to ensure that the lawyer that is retained, and like my firm, what we try and do is maximize the damages and the resolution and lower the cost, so the association is reaping the benefits of the ultimate whatever is taken in.
So we've talked about that, and with the advent of all of the construction being done here in South Florida, someone new to the market is looking at a building to possibly buy in that's still developer controlled. How would they, or what would be the best way for them to check out the developer or the general contractor to see what their history has been with this building process and say the developer turnover or 558 claims? Is there anywhere where they can go and look that up to see that they're dealing with a developer that's either been involved in these, as every developer will, obviously, but just to check up on the reputation, so to speak?
Well, the real estate agent should have a lot of that information, as well as the management company should also provide any prospective purchaser a indication that the developer, other properties within the area that the developer has developed, other projects, and then it is incumbent upon that purchaser to go to those properties to do their due diligence. But I always tell the prospective purchaser, make sure you question your realtor and you make sure the realtor provides you with the appropriate information that you're seeking, because the realtors have a lot more obligation towards their client in terms of representation as to the developer and the product that they're purchasing than maybe that the purchaser may be aware. A lot of times a purchaser thinks their realtor's sole obligation is to just show me properties around town, but it's more than that. The realtor really should tell you the reputation of the developer who built the building, as well as other properties the developer built and how those properties are performing, because real estate or purchasing of a unit is real estate and it's an investment. So that investment should have a level of diligence to understand how other properties that developer performed in the community and whether or not this is a product that the developer stands by.
Terrific. Now, what we'd like to do is we have a couple of questions submitted on the Q&A, which we'd like to get to before we wrap up. And one of them goes to the fact when we first started our discussion today there was the 558, and then there's the blanket term developer turnover. And basically, what are the other issues that you commonly see during the quote unquote developer turnover process that are not construction related that you advise associations to make sure that they address?
Okay, I'll break it down simply to three other issues. One is accounting. So prior to turnover, the developer is required to determine how it wishes to fund the association, whether it's based on the unit-based funding or what's called deficit funding. So the developer is required to fund the operations one of those two ways. And what we see often is the developer underfunds the association. The turnover happens, a bogus budget is reflected, and so the unit owners were paying an amount that really could not sustain the operations of the association, and the association will come in and have a deficit of a couple $100,000, and that they need to seek that from the developer. That we see that a lot. The second issue is at the time of turnover, the developer is required to provide the association with a series of documents, the as-built plans, warranties, and all vendor contracts that the association is involved with that were entered into by the developer. Those contracts entail the cable contract, the valet company, the landscaping company, the beach club, all the various contracts. And the Florida statutes provides that within 18 months after turnover, the unit owners, irrespective of the termination provisions in those contracts or the length of those contracts, the unit owners have the ability through a process detailed in 718 in chapter 718 of the Florida statutes to terminate those contracts lawfully. So it's critical that the association obtain all those contracts and perform an evaluation to see whether or not they conform with the industry. And likewise, management helps to ensure, based upon all the other properties, whether or not the prices that are being paid are in line with the services being received. And then the third item that I always point out are the initial issues that seemingly impact every property are parking, pets, and tenants. And immediately upon turnover, I have the board address those particular issues because prior to turnover, the developer wants to allow its customers and tenants to, I don't want to say have a free-for-all, but have an easy stay, if you will. And sometimes rules and regulations and the governing documents are required to be updated so that the tenants who are not owners, pets at the property, are not creating additional damage to the property. And so the rules would need to be updated to that. And also parking always seems to be a problem too. So you need to ensure that the parking in terms of the spaces where people are parking or valet is all being properly operated. So those are the three, I guess, categories that I always make sure that my clients at the time of turnover pay attention to.
Invaluable information, because we see it from a management standpoint, particularly on the developer budgets. And that can ultimately, affect the association as much as the issues with construction defects.
You're right.
Now, another question that we have is, what is the time frame for the developer that is required for him to turn over all of the documentation and contracts? And what does an association's remedy if they don't do that?
So under the Florida statute 718-203, they have to do that within 90 days after turnover. And if they don't do that, then it's a violation of the statute. The association has the ability through, if it's a condominium association, through the Department of Business and Professional Regulation, to file a complaint and the department will fine the developer and seek to compel turnover based upon the submission of the developer of the property being deemed with the state as a condominium. So there is some teeth there, and they can seek an administrative judgment against these developer companies for the requirement to turn it over. Now, let's say after all that happens, they still don't turn it over, then you would have to file an injunction with circuit court. Let's say now they still don't turn it over. Obviously, there are, vendors that are still working at the property. Hopefully they can provide some of the information. If they don't have the, the as-built drawings, hopefully you can get it from the city. Sometimes you can't. But when you pursue these claims against the developer, if the developer doesn't provide you with that information and they don't give it to you because let's say they didn't keep it, they don't have it, whatever the case may be, they will have spoliated that evidence, and any claims against the developer as a result of damages the association incurred as a result of not having those documents will be deemed as a negative inference against the developer in those claims. So you're in a good position against them, but I'd rather have the documents. But there are avenues to get them.
And then what is another question on this same topic is, what is the definition of the turnover date? Is it a date that the agreed upon number of units are closed, or when the 558 process is concluded?
No, 558 process doesn't even start until after turnover. The turnover process is a requirement under the Florida statutes when the developer has sold a certain number of units. That's when that comes about. Now, some developers have a different idea as to whether it's within 90 days of a certain number of units being sold. Either way, the developer has that requirement. Without a doubt, though, after 50% of the units are sold, the unit owners are required to have at least one board member on the developer-controlled board. And we recommend that if we're a counsel for a pre-turnover association, that a unit owner gets on that board so they have the ability to understand what are the issues affecting the association, and then hopefully they'll run for the board at the time of turnover. So there is some continuity from the pre-turnover developer-controlled board to the unit owner. So at least there is a unit owner that has awareness of the issues.
Great. And now let me ask you to bring up your crystal ball for the moment. As we started out, we mentioned that South Florida has undergone a construction explosion in the market of condominium associations. Do you see anything coming up that legal-wise, legislative-wise, that is going to impact the current 558 statute, or anything else that might be coming down the pike on this new construction boom as it would protect associations?
So I see a couple things happening. One, I see a different level of understanding from the developers and general contractors that these claims are obviously real. There are attorneys out here pushing these files a number of different ways, and in an effort for them to get ahead of themselves, nowadays, in addition to them requiring the certain types of insurance, those wrap policies that I pointed out, they are also putting together a fund to help get ahead of the defects, and so they can hopefully repair any items and put it as part of their fund ahead of time. So I see that happening, and I've seen that at a couple properties. Legislative wise, I do not necessarily see anything that may protect an association. Maybe there's recently been potentially some cases that may actually hurt an association in some of these processes. So it made it a little bit tougher. But plaintiffs' lawyers like myself are cognizant of some of the rulings that have come out impacting how these claims must be pursued. And we have ways around it to ensure that the Florida building codes are being enforced.
Terrific. I can't, at this point, I do not see any more Q&A. And at this point, I would just like to Daryn, to thank you for invaluable information that you gave to the viewers and to our attendees during today. I think one of the things that I think you can take away from all of this is the importance of retaining someone who is done this, who is expert on it, and has had multiple things that they've done over time to make sure that their clients get through the process as expeditiously and as rewarding as possible. And for that, I think there's very few in South Florida like yourself that has done that, and is definitely going forward for any association would be a plus.
Thank you, Doug, for giving me this opportunity. If anybody who participates have any questions, here's my email. Feel free to reach out. Obviously, both your company and my company have a lot of experience in these types of areas, and I can only wish people good luck, and hopefully with guidance that I provided and leadership that your team provides, we can help our clients smoothly get through these and hopefully to the most successful as possible.
Yes, and just to echo that, I look forward to speaking with anybody that is either going through this, contemplating going through it, or if we could be of any assistance to guide you through the process, and along with Daryn's firm would be most welcome to do that. So, and again, I'd like to thank all attendees at this point, and we appreciate your attendance during the webinar. Thank you.